As we learned in the last episode, Temujin Kensu, formerly Fred Freeman, in his pre-conviction life, was now serving life without the possibility of parole in the Michigan prison system. Having been convicted of the crime of first-degree murder in the shotgun death of college student Scott Macklem, the jury had recommended the maximum penalty allowable in the state of Michigan. But true to his rebellious nature, Kensu would not settle silently into life behind bars. Never one to simply surrender, it seems, Kensu began educating himself in, among other subjects, legal matters. Perhaps due to intelligence and charisma, he had also garnered support and assistance from some enormously powerful organizations and individuals who believed him to be innocent of the crime for which he had been sentenced to life in prison. Would his efforts, and those of his many supporters, be rewarded, or would he be constantly frustrated in his attempts to win his freedom? I am your host, Aaron, and this is Framed. Please join us for a close examination of Justice on Trial, the Temujin Kensu story. This is Episode 7, The Appeals, Hope, Heartbreak, and Happiness. Primary research and writing for this podcast by Kathleen McGrath of Thread Pillars Research. Music by the Captain of True Crime Garage. Michigan Department of Corrections System, circa 2000s. Determined to win his freedom, Kensu began working on his appeals shortly after his incarceration. From the outset, he and his attorneys got busy filing reams and reams of paperwork. Without getting too far in the weeds in legalese, we are going to cover some of the key appeals, motions, court orders, and rulings from the early 2000s through present day to the best of our ability. It's important to note that we are not legally trained, but instead have used a variety of publicly available articles and documents in our research. We have tried to state things as accurately as we are able. Kensu's initial attempts to appeal his conviction were unsuccessful. Despite a failed motion to the Michigan Court of Appeals and a denied request to present the case to the state Supreme Court in the 1990s, Kensu pressed on, continuing to proclaim his innocence to anyone and everyone who would listen. The Injustice Busters blog has covered some of his subsequent attempts to win freedom. On October 1, 2004, retired attorney Jonathan Mayer filed a lengthy brief in St. Clair County Circuit Court, requesting that Kensu's case be revisited. Mayer, who had been involved in the case for almost 10 years after receiving a letter from Kensu, believed enough new evidence had come forward to warrant reconsidering the facts of the murder. According to an article in the Detroit Free Press, the brief presented new information pointing to an entirely different suspect. Oral arguments within the weighty 178-page brief were presented during a December 13, 2004 hearing before St. Clair County Circuit Court Judge James Adair. Mayer alleged that the following points should be enough to secure a new trial for Kensu. 1. Joplin, the jailhouse snitch who testified that Freeman had admitted to murdering Macklem, later recanted. 2. Another prisoner told a private investigator in August 2004 that someone he knew had once mentioned killing the child of the Croswell mayor because of a girl. Moreover, this person was linked to another 1986 homicide, a shooting death. 3. The brief stated that both the defense and the prosecution were ineffective and prejudicial during the 1987 trial. Elaborating on the defense aspect of the third point, Mayer submitted that Kensu's trial lawyer, David Dean, provided ineffective counsel, as he was abusing drugs during the trial. Alleging that the defense attorney had routinely shown up in court high on cocaine, he charged that Dean was unable to mount a vigorous defense for his client. Among the many deficiencies he listed, Mayer noted Dean's lack of objection to many portions of the trial, specifically the presentation of Kensu as a crazed ninja killer. Dean subsequently admitted in 1993 to using drugs outside the courtroom and acknowledged his addiction went back 10 years to 1983. However, he insisted that his substance use disorder did not result in providing ineffective counsel to his client. Additionally, Dean adamantly denied that he had prevented Kensu from testifying during trial, maintaining it was his client who had elected not to take the stand. He said that Kensu made the choice because he feared he'd be vulnerable to an attack of his character should he subject himself to cross-examination. According to an Injustice Busters blog post, Dean revealed that he now believes Kensu is a guilty man, maintaining that even as far back as the trial, he became convinced of his client's guilt. He said, "Freeman cannot ever prove that my drug and alcohol abuse had anything to do with him being convicted of killing that man. It's a man reaching for straws. He's a desperate, calculated, cold-blooded killer." Dean, of course, was later disbarred from the practice of law in Michigan, in part for his substance abuse. As for Mayer's contention of prosecutorial misconduct, he claimed the state's case was prejudicial, consistently characterizing the defendant as a crazed ninja killer and relentlessly emphasizing his expertise in martial arts. The brief charged that Prosecutor Cleland also elicited excessive sympathy from the jury by constantly referring to the victim's fiancée, Crystal Merrill, as a poor pregnant farm girl. Despite these considerable efforts, Kensu's sentence was not overturned, and he remained in prison. Maintaining that the right man was behind bars, the St. Clair County Prosecutor's Office rejected the idea that attorneys representing Kensu had produced anything new. They also dismissed the informant, who identified a new suspect as not being a credible witness. So, it was back to the drawing board for Temujin's team. Another bid for freedom was a petition for a writ of habeas corpus filed on Kensu's behalf in January 2007 in U.S. District Court in the Eastern Michigan District in Detroit. The purpose of a habeas corpus motion is to review the legality of a person's continuing imprisonment. If successful, it can result in a conviction being vacated and a retrial mandated. Defense attorney Richard Lustig, who was working pro bono for Kensu, filed the petition that raised several constitutional and procedural issues he contended had occurred during trial. In addition to claiming ineffective assistance of trial and appellate counsel, he alleged prosecutorial misconduct, stating that for the court to even allow Cleland to present the phantom plane theory was unconscionable. The matter of the altered lineup photographs was also raised, with Kensu's team claiming that the relevant information had not been shared with defense counsel at the trial. Other concerns included the matter of actual innocence, supported by new alibi evidence, trial court errors, such as allowing the jury to see Kensu dressed in prison attire and shackles, improper jury instructions, and cumulative error impacting the fairness of the trial. U.S. District Judge Denise Hood would be expected to rule on the case or request oral arguments. In June that same year, the Office of Michigan Attorney General Mike Cox objected, countering with a motion that all judges within the U.S. District Court for the Eastern District of Michigan should recuse themselves, since former prosecuting attorney Robert Cleland was now a sitting judge in the Eastern District. If granted, it would move the appeal to the far more conservative Western District. The Attorney General put forth the objection, saying that it was entirely possible that Cleland could be called as a witness in an evidentiary hearing. This would put the court in the highly uncomfortable position of determining the credibility of a fellow sitting judge in the same Eastern District. In response, Lustig said that the motion should be denied because Judge Hood did not have a personal bias, accusing the Attorney General of forum shopping. According to Wikipedia, forum shopping is the practice of a litigant choosing the most favorable court or jurisdiction in which to bring a case, based on the belief that it will provide the most advantageous outcome. Although all his previous bids for freedom had failed and Kensu had exhausted the appeals process, Federal Judge Denise Page Hood granted the habeas corpus petition on October 14, 2010, thus overturning his guilty verdict. Citing defense attorney misconduct as chief among other issues, the U.S. District Judge said in her 52-page ruling that there were significant errors made during the 1987 trial that had tainted the verdict. An article for a publication called Justice Denied, the Journal for the Wrongly Convicted, reported that specifically, Judge Hood had granted the petition on 3 grounds. The first was ineffective assistance of counsel, including obstruction of petitioner's right to testify in his own defense, and failure to call Michelle Woodworth his main alibi witness. The second, prosecutorial misconduct, including jailhouse informants' concealment of promises by prosecution, Philip Joplin, who made up a Kensu confession in exchange for leniency, and third, ineffective assistance of appellate counsel. At the time of Judge Hood's ruling, Temujin Kensu had been imprisoned for 24 years. His wife Amiko was elated by the decision, telling reporters, "It's been 24 years. To say you're innocent for 24 years and to finally have someone acknowledge that things weren't right in the trial is uplifting." While Kensu and his supporters may have been ecstatic over this turn of events, the ruling likely struck fear in the hearts of those who opposed his release. And, as we will discover a little later in the podcast, this was not limited to just Scott Macklem's friends and family. Also in 2010, just a month before Judge Hood filed the habeas petition, Kensu had undergone a public commutation hearing. After 2 days of testimony, unusual in and of itself, the state parole board recommended 11-0 against commuting Kensu's sentence. The case then went in front of Governor Jennifer Granholm, who followed the board's recommendation and rejected clemency for Kensu in December of that same year. Regardless of this disappointing outcome, Kensu and his supporters still had Judge Hood's decision to hang their hats on, which was making its way through the court system. Regardless, that feeling of optimism at the Kensu camp would quickly be replaced by dejection. The paperwork was not submitted on time, so the ruling reverted to the original guilty verdict. In May 2012, the United States Court of Appeals for the Sixth Circuit formally reversed Hood's decision. Writing about it in his Proving Innocence blog, David Sanders wrote, "Unfortunately, the Sixth Circuit overruled Hood on purely procedural grounds, tardy filing, having nothing to do with his actual innocence. Further appeals to this date have not been successful." In November that same year, the Michigan Supreme Court referred the case back to the St. Clair County Circuit Court. 2 years later, in November 2014, Circuit Judge Michael West issued an opinion denying Kensu's motion for a new trial. Kensu's old nemesis, Robert Cleland, now Judge Cleland, had testified at the evidentiary hearing, which had been held in March. Former trial attorney David Dean also testified via telephone. An article in the Times-Herald reported that Judge West had ruled that Kensu had not offered any new evidence, that Dean had provided insufficient information about the altered lineup photographs used during trial. Nor did they find his claim of ineffective assistance of counsel to be substantiated. His quote from the article reads, "Memories have been lost, not just faded. Witnesses have died," West wrote in his opinion. Present-day technology and its application to police record-keeping and evidence preservation, pretrial discovery, and criminal trial practice is barely recognizable when compared to 1986. All of these factors are present in this case and favor not upsetting this criminal judgment. As expected, Kensu's representatives at the University of Michigan Innocence Clinic expressed their disappointment, but assured the media of their intention to appeal this latest denial. Meanwhile, Kensu's legal activities were not simply limited to filing an avalanche of motions and appeals seeking to overturn his conviction. Another matter Temujin did not shrink from was fighting for prisoner rights, his own as well as others. Putting his jailhouse lawyering to good use, he got busy litigating. In July of 2009, Kensu had re-injured a pre-existing partial rotator cuff tear in his right arm and developed a right hamstring rupture. He subsequently successfully sued the Saginaw Correctional Facility, where he was now incarcerated, for negligence. In addition to suing the treating medical staff, including those responsible for his various injuries, he also claimed the facility's failure to allow him to seek treatment, recommended by his orthopedist, caused his injury to worsen. He alleged that the facility's failure to provide proper care exacerbated the injury. The case, presented in front of Judge Victoria A. Roberts, was based on the Eighth Amendment and the violation of prisoners' rights. After a 5-day trial in March of 2016, a jury ruled that the care team staff at Saginaw Correctional were deliberately indifferent to Kensu's medical needs. He was awarded $325,002, including punitive damages totaling $285,000. Perhaps buoyed by this victory, Kensu began papering the Michigan Department of Corrections, or MDOC, with grievances. Filing what sources termed as a flurry of lawsuits against the MDOC, he also put Corizon Incorporated, a private prisoner healthcare provider, in his crosshairs. Kensu's litigious endeavors continued as he sued on behalf of himself and others to improve prison nutritional programs. In 2021, he filed a class action lawsuit, alleging that the Michigan Department of Corrections failed to provide inmates with adequate food and medically necessary diets. However, the district court ruled against Kensu without going to trial and refused to let him turn the lawsuit into a class action. A December 2021 article in Prison Legal News, a project of the Human Rights Defense Center, described the eventual dismissal of Kensu's Corizon lawsuit as well. Characterizing the petition as a morass of irrelevancies, the article related that the district court's decision was based on the lengthy, confusing, and unrelated litany of allegations that the plaintiff, Kensu, was charging. After being given 2 opportunities to amend the suit and failing to do so, he was warned that the third attempt would be his last. Again, he persisted in including irrelevant and unspecific allegations in his petition, effectively ignoring instructions to clarify what the lawsuit was about. Believing this indicated an inability or unwillingness to comply with the district court's orders, the district court's order was affirmed, and Kensu's lawsuit was dismissed with prejudice. This means that this ship had sailed, the matter was closed, and Kensu was unable to refile the case against the healthcare provider. As Kensu was occupied suing MDOC and Corizon, attempts to overturn his conviction continued. In 2017, according to David Sanders' wrongful conviction report, the Sixth Circuit Court of Appeals affirmed Kensu's claims of prosecutorial misconduct and malfeasance to include proving beyond a reasonable doubt that the prosecutor and Port Huron officials deliberately and maliciously withheld critical photographic evidence from the defense for years, characterizing this as a clear Brady violation. The claim also asserted that the original photo array of possible suspects shown to witnesses was not the one that was presented to the jury. In it, Kensu's team maintained the prosecution deliberately and illegally altered those photos before the trial, with a specific intention to deceive. Moreover, they had knowingly lied about this to the jury by presenting a completely fabricated photo board. The result was that the Sixth Circuit Court granted Kensu leave to file a successive habeas petition, finding that he had made a prima facie, showing that the claims were based on new evidence. Prima facie, Latin for at first sight, simply means that he had provided enough initial evidence to suggest that his claims were based on new evidence that could potentially impact his case. In other words, taken at face value, the claim had merit. This opened a door for Kensu to challenge his conviction based on newly discovered facts, in essence, the photo array evidence. It seemed like things might be looking up at last for Kensu and his supporters. The Michigan Innocence Clinic filed the petition on Kensu's behalf. Due to conflicts of interest in the Eastern District of Michigan, remember, former prosecutor Cleland was now a sitting judge on the district bench, the case was punted to another judge in the Eastern District of Kentucky. In 2019, the habeas petition was again denied, with the judge declining to issue a certificate of appealability. This essentially signaled that the case did not meet the legal threshold for further review. This denial represented yet another significant setback to Kensu's team. In a June 2019 blog post for Proving Innocence, David Sanders alleged that the latest Sixth Circuit Court of Appeals ruling contained false and deceptive statements and was filled with errors and misinformation. Observing that it was not signed by any judge, which he deemed unusual, he speculated as to why this might be the case. He concluded that no judge wanted their reputation linked to such a false and misleading document. The Post maintained that the court was clearly more interested in protecting one of their own, that is, federal Judge Cleland, than in ensuring justice had been served. It accused Cleland of securing a false conviction, primarily through his own misconduct. Pointing to what was described as specific misstatements and errors, the article faulted the court for diverting attention from what it characterized as evidence of Kensu's actual innocence. For example, the blog entry claimed that the court order included the glaringly false statement that Richard Kruger identified Freeman as the man he saw standing in the parking lot where the murder occurred approximately 1 hour before Macklem was shot. The author countered that Kruger was, in fact, in the McMorran Arena area, not the parking lot where Scott was killed. Similarly, the statement both Gobine and Kruger identified Freeman from a photographic lineup and later made in-court identifications was obviously incorrect, as it failed to mention that Kruger had instead identified a man named James Loxton in the in-person lineup. Then there is the matter of the Green Army jacket, which was brought up in trial testimony and continued to be debated during the appeals process. Among the many other inaccuracies and discrepancies, the blog post claimed that the court order contained, there was the contention that 2 witnesses observed the suspicious man in the parking lot wearing a Green Army-style jacket and that police found a Green Army-style jacket in Freeman's car. While it is true that a similar style jacket was found in the trunk of the vehicle Kensu had been driving at the time of his arrest, the marquee was actually registered to Tom Ford, not Kensu. As it turned out, the jacket belonged to Ford's brother. Kensu was more of a black leather jacket or a black wool peacoat kind of guy. Even if the army jacket had belonged to Kensu, this wasn't exactly the bombshell discovery that the court may have considered it to be. Considering the multitude of men, not to mention women, who had this exact article of clothing hanging in their closets in the late 1980s, it was hardly a smoking gun, especially since there wasn't a trace of gunshot residue on the fabric of the coat found among Kensu's possessions. After pointing out what the author termed as numerous additional errors and false statements, the blog entry concluded that the 9 alibi witnesses had unequivocally proven Kensu's innocence, stating that had the prosecutor's misconduct, which he maintained included inventing evidence and coercing false testimony, been revealed to the jury, no reasonable observer could have found Temujin Kensu guilty. An editor's note at the beginning of the 2019 blog post had described Michigan's court system as woefully ineffectual and corrupt, committed to enabling injustice. The author suggested that instead of repeating the endless cycle of self-defeating and pointless appeals through the system, they would be better served to turn their attention to the newly formed Conviction Integrity Unit, CIU. Created in 2019 by Michigan Attorney General Dana Nessel, its purpose was to specifically investigate credible claims of innocence to ensure no one is convicted of a crime they didn't actually commit, as related in a press release from the Michigan Department of the Attorney General. Alternately branded the AGCIU, or Attorney General Conviction Integrity Unit, it was headed by highly respected and experienced criminal defense attorney Robin B. Frankel. Now characterizing Kensu as having reached political prisoner status, Sanders and other Kensu advocates hope to seek relief from this newly formed unit. Their hopes would be crushed yet again in May 2022 when Kensu's petition for freedom was again rejected by the AGCIU. Kensu's supporters had expected a positive result from the petition, given they were able to provide what they considered new evidence in the form of Beth Steer, the young woman Kensu had been on a date with in the early morning hours of November 5, 1986. According to Barbara Kennedy, an attorney for proving innocence, Beth's alibi account was discovered via a FOIA request filed by the Michigan State Police. Since her existence was not disclosed during the 1987 trial, they reasoned, it was new evidence of Kensu's innocence. However, in a denial letter, the CIU maintained the reason for rejecting his claim, refusing to grant relief, and closing the case was that new evidence had not been provided. In a letter explaining the denial of the claim, Valerie Newman, Special Assistant Attorney General with the CIU, defined new evidence as evidence not at all considered at trial or during post-conviction appeals. Her reason for the refusal was that, despite the lack of disclosure during the trial, Steer's alibi testimony was not new evidence. Instead, she said, it was merely supportive of the other alibi witnesses' accounts, therefore did not rise to the level required. At this juncture, it seemed that Kensu's only hope for release rested in the hands of Michigan Governor Gretchen Whitmer. He has twice bid for clemency from Whitmer, his first bid having been rejected in 2021. He filed a second bid in 2022, for which he is still awaiting a decision. Despite these disappointing hurdles, the situation was not all doom and gloom for Kensu. Temujin had good reason to celebrate in 2022. On November 4th, he married a woman named Paula Randolph, whom he'd fallen in love with despite being behind bars. Of course, their romance started out just a little differently than most love stories. Having corresponded with him for a while, since late 2019, Paula told him that she wanted to meet him in person, seeing as she drove by the prison several times a week. Paula recalled this as an emotional, memorable visit. Apparently, she was Kensu's first personal, non-legal visitor in many months. During their meeting in the cold, drab prison visiting room, the two mainly discussed the loved ones Temujin had lost. Within the sterile atmosphere of these stark and unforgiving walls, Paula said he opened up and became quite vulnerable with her. Knowing that at the end of the visit, she would be able to leave, but he would have to stay behind, Paula found herself tremendously moved by how difficult life behind bars must be for him. Temujin, evidently true to his nature, proposed to her on that first prison date. Given Kensu's propensity to be incredibly persuasive in order to get what he wants, this will surprise no one who has followed along with us so far. But as it turned out, Paula too was smitten, and she quickly joined Kensu's team of supporters, becoming his fiercest and most fearless advocate. Their happiness culminated on November 4th, 2022, when Paula Randolph, resplendent in a long white wedding gown with a beaded bodice, exchanged vows with Temujin Kensu. An article for the Detroit News by Nolan Finley, who has written several pieces on the case outlining the fight for Kensu's freedom, described the couple's union. The groom wore prison blues, as he was not granted permission to wear a suit and tie. Despite the dubious ambience of the Macomb Correctional Facility, the couple were joyful participants in the ceremony and the brief reception that followed, which was attended by 4 treasured guests. Immediately following the reception, Paula would be forced to leave the prison to spend her wedding night alone. Undaunted, however, Paula has made it her mission to move whatever mountains are needed to someday bring her husband home. She has vowed to her last dying breath that one day, both she and her husband will be able to move freely about the outside world. Meanwhile, the couple would continue to wait for news regarding the outcome of Kensu's second bid for clemency from Governor Gretchen Whitmer. But, as it turned out, not all women were as infatuated with Temujin Kensu as his new bride was. The contents of that failed 2010 commutation hearing, whose transcripts were recently shared with several podcasters, would reveal that multiple women had quite a bit to say about their past relationships with him, and none of it was good. Next, on Justice on Trial, the Temujin Kensu story. Episode 8, The Aftermath, 3 sides to every story. The anguish over the lost habeas petition wasn't the only difficulty that Temujin Kensu and his supporters would face in the fall of 2010. A month before the decision, he stood before the Michigan State Parole Board, hoping to have his sentence commuted, and ultimately win his freedom. But as the board peppered him with questions designed to assess his readiness for release, Kensu seemed to be his own worst enemy. And when multiple witnesses stepped forward to strenuously oppose his freedom, the weight of their testimony once again crushed his hopes of walking beyond the prison walls. Despite this considerable and rather alarming oppositional testimony, many influential advocacy organizations and powerful supporters remained steadfast in their belief in Kensu's innocence, sustaining their efforts in the hopes of reversing what they considered his wrongful conviction. But were his advocates engaging in a righteous battle to correct a grave injustice, or were they instead unwitting pawns in a masterfully orchestrated deception?